Another form of damages recognized by the law of torts is punitive damages. Punitive damages are damages that are awarded to the plaintiff for the purpose of punishing the defendant. Sometimes they're called exemplary damages because they're designed to make an example of the defendant. Punitive or exemplary damages obviously can only be awarded when the defendant has done something that merits punishment. And the law is really quite specific about that. In intentional tort cases, punitive damages may be available, but only when the defendant has acted with malice, which is an actual desire to cause harm. Remember when we talked at the very beginning of this review, I said most of the time the law of torts is not concerned with motive, is not concerned with the defendant's reason for doing something. But when the law is trying to decide whether to award punitive damages, it's very concerned with motive. If the defendant's motive was to cause harm, then the defendant might be liable for punitive damages. In negligence cases, punitive damages are not available at all because we don't think a person should be punished for negligence, although he or she may have to pay for the results of negligence, but we don't think punishment should be imposed. However, there's a certain kind of negligence which is very serious, so serious it's actually a separate form of fault. It's called aggravated negligence. Negligence is a breach of the duty of reasonable care, but aggravated negligence goes beyond that. Aggravated negligence is the willful disregard of an obvious risk with a high probability of serious harm. Not just a foreseeable risk, but an obvious risk with a high probability of serious harm. Not just an unreasonable disregard of that risk, but a willful disregard of that risk. We're talking about damages, but I'm going to give you an example to explain what aggravated negligence really is, because then we won't have to talk about aggravated negligence anymore. Suppose that I see a crowd of people out in the street and I point my shotgun at the crowd and I fire it. If any of the shot strike people in the crowd, the chances are they will have intentional tort actions against me because I must have known to a substantial degree of certainty that firing into the crowd would result in contact with some of those people. Now, suppose I'm in a very, very rural area where nobody ever comes by my house. Oh, maybe once every 5 years the tax assessor comes by. But except for that, no one ever comes near my house. Very rural area. And it's New Year's Eve and I want to make a noise, so I stick my shotgun out the window and I fire it without even looking where I'm firing. It just happens that someone is passing by and he gets struck by the shot. I think that person will probably have a pretty good negligence case against me because there was a foreseeable risk and I acted unreasonably in the face of it. But suppose that I'm living in the city and I'm living on a street which is not a very busy street, but people pass by every now and then on the street, a street in a residential portion of the city. And I stick the shotgun out the window and I fire without looking. Yeah, that's probably negligence. Probably it's not intent because I wasn't substantially certain that the shot would hit anybody. But in the city, where there is some degree of traffic passing by, the risk of harm is not only foreseeable, it's an obvious risk with a high probability of harm. And shooting a shotgun makes it a high probability of serious harm. And knowing that, because after all I live on that street, knowing that, and willfully disregarding that risk, I fired the shotgun out the window anyway, probably a person who was injured by that shot can make out a case against me for aggravated negligence. And if so, he or she may be able to collect punitive damages. So punitive damages are available in intentional tort cases when there is malice. Punitive damages are not available in negligence cases, but they may be available in cases of aggravated negligence. Probably the most important kind of damages that the law of torts is concerned with is compensatory damages. Damages designed to compensate the plaintiff for the harm he or she has sustained. And we don't have to worry about how compensatory damages are calculated. Usually, that's the job of a jury. However, there are a few rules of compensatory damages that you're going to be looking at in your torts class. or have looked at in your torts class and that we need to review. One is the collateral sources rule. The collateral sources rule says that if the plaintiff has received money from anybody other than a tortfeasor or somebody paying on behalf of the tortfeasor, that money has nothing to do with the tortfeasor's liability. For example, you negligently run me over and break my leg, and that causes $100,000 worth of damage. But I have an insurance policy that has agreed to pay me $50,000 for a broken leg no matter how I get it. And I collect $50,000 from my insurance company. Now I sue you for the $100,000 that your negligence cost me. And you say, well, wait a minute, Finn's already got $50,000, so I only owe him another $50,000. The collateral sources rule says that the court should not listen to your argument because the money I received wasn't from a tortfeasor or somebody paying on behalf of a tortfeasor. It wasn't from your insurance company. It was from my insurance company. It was something that came from a collateral source. I paid the insurance premiums. You shouldn't be the one to get the benefit of it. You negligently break my leg. Usually it would cost $5,000 doctor bills for a broken leg like that. But I have a real good friend who's a doctor, and he agrees to fix my leg for me for free. I'm still entitled to collect the $5,000 from you because the gift that I got from that doctor friend of mine was from a collateral source, and it's not something for which you should receive benefit. That's the collateral sources rule. You should also be aware of the plaintiff's duty to mitigate damages. When a plaintiff sustains an injury, a plaintiff is supposed to act reasonably to minimize that injury.
I had my car insurance with Farmers Insurance, full coverage, so the $30,000 came into play, so the collateral source would not be, wouldn't be able to use that at all in any way. The tort individual that created the or implemented the tort is responsible. So look at your policies on your own personal vehicles. They cover you. Mine covered mine. I was paid $30 grand. And for police officers and paramedics and firemen, those that drive on the job, your own medical on your own personal vehicle will cover you. So that's good information to know.
Gently cut me, I ought to do something about the cut. Wash it, maybe put some iodine on it, something to keep it from getting worse. And if I don't do something about the cut and it does get worse, it gets infected, it gets ulcerated, maybe finally my arm has to be amputated, you should not have to pay for any damage that I could have avoided by acting reasonably myself. So if you can establish that the reasonable person in my shoes would have put iodine on the cut and that would have prevented the infection and prevented the amputation, then you won't have to pay for the amputation or the infection because of the plaintiff's duty to mitigate damages. Another rule you should be aware of in connection with damages in negligence cases relates to lost profits. For a number of reasons, some of which you'll probably be discussing in your torts class, the courts have held that lost profits cannot be recovered in negligence cases. Suppose, for example, that as a result of your negligence, my ship is damaged, or the river is blocked, so that I am not able to deliver the load of wheat that was loaded on my ship to a buyer who's located at the other end of the river. Most jurisdictions would agree that I cannot collect from you for the profit that I lost as a result of my inability to complete the sale. And that's a matter of policy, and it's probably because there really is no limit to what those business losses might be. So the general rule is that business losses or lost profits are not recoverable in a negligence case. Now, you need to understand what the existing rule is about recovery for mental disturbance resulting from negligence. The majority of jurisdictions have held that in a negligence case, I cannot recover for my mental suffering unless it was either the result of a physical injury or it had a physical manifestation. Oh, if you drive your car negligently and you strike me and you break my leg, and in addition to the pain that I experience with my broken leg, I feel very depressed because I can't go to school and I can't go out on dates and so forth. well, I may be entitled to recover for that mental suffering, that depression, because it was the result of a physical injury. If you're driving